Good morning, everyone.
Good morning.
Good morning.
Good morning.
Oh yeah, I thought I was muted. I guess not.
Can you guys hear me? Okay.
All right, good morning, everyone. My
Good morning.
apologies for the late start. We're missing a court reporter. If any of you need to have your matters taken down today, we may have a little bit of wait before we can handle your matter, but at least in the meantime, I'm going to go ahead and call the calendar and see what we have ready. Position 1 is National Collegiate Student Loan Trust versus Tiffany Parks.
Daniel Green for plaintiff.
Position 2, Louis Brisbois versus Joy Unije.
Joy Unij on the line, Your Honor.
Do we have plaintiff here, Louis Brisbois?
Yes, Your Honor. Deasia Bellamy on behalf of Louis Brisbois.
All right. Position 3, E.T. Gutter Parker versus Sharina Morgan.
Present, Your Honor, on behalf of the plaintiff.
Your Honor, this is Sherry Washington on behalf of defense. And this was for a status, and we have a quick status if you are so inclined to take it.
Let me hear it.
So we have, you ordered arbitration. We have arbitration completed. We just got the email yesterday that they have the award ready. And so we're anticipating the award.
Your Honor, that's partially correct. We received notice that arbitration award on September 6th, and we were asked to pay.
Ms. Parker, you're breaking up. We'll have to come back to you.
Can you hear me, Your Honor?
All right, try it one more time.
Okay. We received notice on September 6th that the arbitration was ready. The plaintiff has, the defendant has,
I'm sorry, you're going to have to rejoin. We're going to have to
award
come
will
back
not
to
be
you.
released.
We're going to have to come back to you. All right, position 4, Travelers Property Casualty Company versus Atlantic Construction.
Brandon Davis here for the plaintiff, Your Honor, Travelers.
They sent the money back.
All right, position 5, National Collegiate Student Loan Trust versus Daniel Freeman.
And Daniel Green for plaintiff.
Good morning, Your Honor. Danielle and Sharon Freeman present.
All right. Position 6, Absolute Resolutions Investments versus Megida. I think we've signed the judgment on that one. Position 7, Midland Funding versus Cynthia Cofield. That was a dismissal. Position 8, Midland Credit Management versus Kimberly Wright.
Daniel Green for plaintiff, Judge.
Kimberly Wright. All right, position 9, Midland Credit Management versus Jocelyn Parfait.
Daniel Green for plaintiff.
Position 10, Citibank versus Jennings.
Daniel Green for plaintiff.
Position 11, JP Morgan Chase versus Daryl Williams.
Daniel Green for plaintiff. Judge, that is my last case. You're doing breakout rooms. I'm wondering if you could put me in the breakout room on position 5. Or I could just wait.
With Danielle Freeman. All right.
I turned it on. Oh. That's it. Oh, God. Mhm.
All right. Let's go to position 13, Kelly Okoro versus Terrence Gunn.
Good morning, Your Honor. Walter Gabriel for the plaintiff. I'm actually going to join with defense counsel's request for a continuance for today's hearing.
Natalie Wilkes for State Farm, UM Carrier.
And Cameron McKinney for Mr. Gunn, the defendant.
All right, and why do we need a continuance? This was a motion for a default judgment. As I looked at the pleadings, it seemed like there was a timely answer filed. So I'm not sure what the need is for the continuance. Somebody give me a brief explanation on that.
I'll be brief and let Mr. McKinney follow. We believe we're going to reach a settlement pretty soon in this case. We have a deposition scheduled, I believe, for October 6th. I also filed an amended complaint this past Friday, and I just wanted to make sure there weren't any procedural defects with today.
Yes, Your Honor, and I do agree with that. And as you stated, there was a timely answer file. And so I spoke with Mr. Gabriel, and I'm not challenging jurisdiction, nor am I challenging liability on this case. So we just want to move forward towards a resolution.
All right. So we shouldn't be contesting the reason why it was put on this calendar was for the motion for default judgment. And I understand, is that withdrawn?
Your Honor, I'm willing to withdraw the motion as well.
All right. So that's withdrawn. And it'll come up again in due course on the next, I think it would be on the next trial calendar is when it would come up. So hopefully you can get it resolved before then.
Looking forward to it. Thank you, Your Honor.
Thank you, Your Honor.
All right, y'all may be excused.
Thank you.
Position 14, Asia Barber versus Dwight Holloway. Motions were withdrawn. Position 15, Ernst Enterprises versus the Concrete Lady.
Good morning, Your Honor. Jeff Nickerson for the plaintiff. My witness is here. Should take us about 5 minutes.
All right, thank you. All right, position 16, Plateau West Homeowners Association versus Barrett.
Ben Ost on behalf of plaintiff, Your Honor, this matter stands in default. I have one witness, about 5 minutes.
All right. Position 17, Waters Cove Homeowners Association versus Stafford.
Same announcement, Your Honor.
Right. And position 18, Deep Creek on High Point Homeowners Association versus Carter.
Ms.
Same
Carter.
announcement for plaintiff, Your Honor.
All right, and Ms. Carter is here. All right. All right, let's let's start with your cases, Mr. Green, since you've got a lot of them and some of
I
them.
actually have some quick announcements, Your Honor.
Right.
Position one, this is one where we filed a motion to lift the stay, which I don't think has been ruled on. I don't need any oral argument on it. I believe that the brief submitted. And then once that stay is lifted, I believe that we would be ready to proceed.
I think that one, hold on, let me take a look.
Actually, Judge, you have lifted the stay. So this is the current posture of the case. It is in default. We filed a motion well, there was an answer in this case. I would move to just strike the answer and submit a proposed order to Mr. Townsend.
All right, so I've got the motion for summary judgment as to liability, I believe. Oh, I'm looking at the wrong one.
The last order from this court, Judge, was on July 21st, 2021, which did lift the stay. I don't see.
For summary judgment, I must have.
Yeah,
made a
there.
mistake looking at that.
And in our complaint, Your Honor, we did include a business records affidavit. But if you would like to have us formally file a motion for summary judgment, we can do that.
I don't see the affidavit.
Okay.
It's not attached to the complaint.
Yeah, I'm looking to, Judge. I guess what I would like to see is if we could just get one continuance so we could submit a motion for summary judgment in this case.
All right. We'll grant you a continuance to get that done.
Thank you. Position 5, Judge, has been settled. That's National Collegiate versus Daniel Freeman et al. They've returned the consent to us.
All right. The two Ms. Freemans, that's correct? Y'all have reached an agreement?
Yes, sir.
All right. So it sounds like there's some documentation that needs to be taken care of, and then I'll look for a dismissal, Mr. Green?
Yes, Judge.
All right.
Or we'll be filing a consent, and not a dismissal, Judge, because they've done a payment plan.
All right, a consent judgment.
Thank you.
All right.
I'm sorry, can I
Judge.
just chime in just a quick second? I just wanted to know if we're free to be dismissed, Judge.
Yes, you are free to go today.
Thank you. You guys have a good day.
You too.
Thank you. You too. Judge, position 8, we would just, positions 8, 9, 10, and 11, if we can just get one continuance, we'll file a motion for default judgment within the next 30 days.
All right. Nine, 10, and 11. All right.
And that would conclude my cases, Your Honor.
All right, Green, you are excused.
Thank you, Judge. Good to see you.
All right, let's try Ms. Gooder Parker and Ms. Washington again. Let's see if we've got a better connection, Ms. Parker. You were trying to report on the arbitration.
Yes, Your Honor. what opposing counsel had indicated was partially true. The arbitrator's award was released, had been decided on September 6th. We were asked to make payment so that the award couldn't be released. It has not been released because the defendant has not yet fully paid the arbitrator.
So, Your Honor, I was trying to do this discreetly so that I would not say anything against the mediation company, but what actually happened is that we paid the mediation in full about 2 to 3 weeks after the arbitration. I received a check for the full amount of my client's mediation. I did not know what to do with the check, so I deposited it in my account thinking that I was going to have to write a check because it was written to my law firm. I thought I was going to have to write a check to my client. I contacted Miles Mediation first. They said that it took them about 2 days to tell me that was an error. So then I rewrote them a check. I just received a text from Mr. Shaw asking me the status of the check. I told him that I'd already sent the check. And so yesterday when I received the email saying that they were still awaiting payment, that is when I realized that there was still, the check was still out. It has not cleared my account. So now I need to figure out what's going on with the check that I sent, and which I'll probably have to cancel that check and just do the payment with a credit card. But I was trying to keep everything clear. But she made her payment the day before we had the arbitration.
And Your Honor, just for point of clarification, there were 2 different payments that needed to be made to the arbitrator. The initial amount, which was
Ms. Parker and Ms. Washington, frankly, I don't need this level of detail. I want the case to be resolved. It seems like at every stage, there has been some hiccup that y'all can't seem to get the case resolved. We're gonna put it on the calendar again in the next 30 days. And we're gonna hopefully have a final resolution on this.
Thank you, Your Honor.
All right, if y'all can be excused. All right, let's go to position 4, Travelers Property Casualty Company versus Atlantic Construction.
Yes, Your Honor, we're ready to proceed. I do have a witness online.
All right, let's go ahead with your proof. This is a hearing on damages.
Okay. Mr. Eddie Torres, you available? Okay, perfect. Mr. Eddie Torres is my witness. Mr. Torres, can you please raise your right hand, sir? Do you swear that the testimony that you will give today will be the truth, the whole truth and nothing but the truth?
I do.
Okay. Mr. Torres, where are you employed?
Travelers Insurance.
Okay. And what is your title at Travelers?
Senior Premium Auditor.
And how long have you been in that position?
I've been a premium auditor for 7 years, and the past 2.5 years, I've been a senior premium auditor.
Okay. So you are familiar with the audit procedures at Travelers?
Yes, sir. That's correct.
Okay. And why are the audits conducted at Travelers?
When you have a commercial insurance policy, the premium is truly an estimate until we conduct the audit. Nobody knows how their business is going to operate within the year due to circumstances. So the only time we can tell the actual premium is at the end of the policy period when we come in and review their records to see how much revenue they had or how much payroll they had or whatever the applicable measure is for the premium.
Okay. Mr. Torres, are you familiar with the way records are kept during the normal course of business at Travelers?
Yes, sir.
Are you familiar with the declaration page at Travelers?
Yes, sir.
Have you had an opportunity to review the insurance, workers' comp, employer liability policy involving insured Atlanta Construction?
Yes, sir.
Okay. Your Honor, at this time, I would like to submit to the court workers' compensation, the policy as plaintiff's exhibit A, and I will share my screen so I can, oh, I'm sorry. I've been disabled.
I think I've enabled it now, so try it again.
Okay. Mr. Torres, can you identify this document?
Right now, I just see a form. This is policy exhibit A. The document's not visible. It might be on a different screen. I'm not sure.
I think we may have lost him. All right, Mr. Torres, sorry about that. Sit tight. We'll move on to next folks who are ready, and we'll come back to you. Let's go to position 15, Ernst Enterprises versus the Concrete Lady.
Your Honor, this is a suit by Ernst Enterprises for the unpaid balance of the sales price of concrete products that a plaintiff furnished to a company called the Concrete Lady LLC. The plaintiff has also sued an additional defendant, Selene D. Parker, on her personal written guarantee of the obligations of the Concrete Lady LLC. The suit was filed on January 27 of 2021. The guarantor was served on February 18 of 2021. The Concrete Lady, the principal defendant, was served on April 22, 2021. Plaintiff has filed separate motions for default judgment against each defendant. The one against the guarantor was filed on June 30, 2021, and the motion for default judgment against the Concrete Lady was filed on August 5, 2021. I have one witness, Ms. Tracy Kofer. Ms. Kofer, would you please raise your right hand and take the oath? Do you solemnly swear under penalty of perjury that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Would you tell the judge your full name, please?
Tracy Lynn Kofer,
And by whom are you employed?
Ernst Enterprises of Georgia.
And what is the business of Ernst?
We are a ready-mix concrete supplier.
What is your position or title there?
I'm the credit manager.
What does that involve from day to day?
Day-to-day is processing all new credit applications and credit and collection efforts.
Is the concrete, is the Concrete Lady LLC a customer of Ernst?
Yes.
Are you familiar with their account?
Yes, sir.
Let me put up on display Plaintiff's Exhibit 1. Can you see it, Judge?
I can see it, yes.
Yes.
Can you see it, Ms. Kofer?
Yes, sir. Mhm.
All right. Would you tell us what that is?
That is the application for credit and the personal guarantee that was filled out and signed by Ms. Shalini D. Parker of the Concrete Lady LLC.
All right. The first page is the application, and then there's a second page with terms of sale. And then the personal guarantee is on the third page, right?
Yes.
Okay. Has Concrete Lady in fact bought concrete products from Ernst?
Yes, she has.
Have they paid for them all?
No.
Let me ask you to look at Plaintiff's Exhibit 2. And can you identify that series of invoices, please?
Yes, sir. Those are the unpaid invoices on Ms. Parker's account.
Did the Concrete Lady request that Ernst Enterprises furnish the concrete products listed in those invoices?
Yes, she did.
And did in fact Ernst Enterprises furnish the concrete products listed in these invoices?
Yes.
All right, let me ask you to look at Plaintiff's Exhibit 3 and tell the judge what that is.
That is a detailed statement of account that shows all open invoices, the balances past due, and the total amount due.
And the second page is a little small. Can you tell us the total amount due in principal?
Yes, sir. The principal amount is $39,889.42.
Are you familiar with the methods and practices of Ernst Concrete for creating and obtaining and keeping records like Plaintiff's Exhibits 1 through 3?
Yes.
Were Plaintiff's Exhibits 1 through 3 created or obtained at or near the time of the transactions to which they relate?
Yes.
Were they created or obtained by or from information transmitted by employees of Ernst Concrete with personal knowledge of the transactions reflected in them and the business duty to create the invoices and the other records?
Yes, sir.
Were Plaintiff's Exhibits 1 through 3 routinely made in the ordinary course of the business of Ernst Concrete?
Yes, they were.
Kept in the ordinary course of the business of Ernst Concrete? I didn't hear your answer.
Yes, sir.
And were they, was it part of the ordinary course of business of Ernst Concrete to keep records such as these?
Yes.
Your Honor, we move to admit Plaintiff's Exhibits 1 through 3.
Scroll down on plaintiffs 2, if I can see page view so I can see the whole.
It's a series of invoices, probably 16 or so invoices, Your Honor.
Are these attached somewhere to your complaint or your?
They are. They are. They're attached to the complaint. It goes on and on.
All right, I see them. All right, plaintiffs 1 through 3 are admitted.
All right, Your Honor, the plaintiff, in addition to the principal amount, is also seeking interest on attorney's fees as provided for in the terms and conditions of the credit application. And since that is only a matter of mathematics, I have put together a spreadsheet in which I calculated first the interest. I took each invoice and calculated the interest up and through the date of the last invoice, the date the last invoice was due, which was 10/16/2019. And then I calculated that based on that balance, the interest from there on. So I have two interest figures, one for invoices through 10/16/19, and a second for invoices, excuse me, and a second for the interest after that. I put them together for the total interest of $14,744.93. Interest was calculated on the stated interest rate in the contract, in the terms and conditions of the credit application, which was 18% per annum, 1.5% per month. As far as attorney's fees, I took the total amount of principal and interest, took 15% of the first 500 and 10% of the balance, and came up with an attorney's fee figure of $5,400.73. So what we're seeking in this case, Your Honor, is principal of $39,889.02, interest of $14,744.93, and attorney's fees of $5,400.73, totaling $60,034.67.
And tell me the basis for the attorney's fees.
In the terms and conditions of Plaintiff's Exhibit 1, Your Honor, which I'll put up on the screen, it's a credit application which sets out, which is signed by the applicant. In this case, the applicant was the Concrete Lady LLC. Ms. Selene D. Parker signed it on behalf of the Concrete Lady LLC, and attached to the application and made a part of it are terms and conditions of sale, which provide that all sales are net due and payable 30 days from the date of the invoice, and pay and interest, they call it a service charge, but it's an interest of 1.5% per month. 18% per year is charged on accounts that are not paid when due. And I think that further down in item 5 is the provision for attorney's fees. It's 15%. I calculated at the statutory rate of 15% and plus 10%.
But here's the issue is that I don't see the request for attorney's fees in your complaint. And I didn't see it on the proposed order that y'all submitted. The rest of the amounts line up, but it doesn't appear that attorney's fees were requested as part of the complaint.
Just looking at the complaint, Your Honor.
Unless there's an amendment that I missed.
We did ask for attorney's fees in the demand, in the prayer of the complaint, Your Honor. In the wherefore paragraph down at the bottom of the second page.
I don't think I'm looking at the. I don't think I'm looking at the
Sorry,
same complaint.
I'm looking at a different complaint. I beg your pardon. All right. I agree. There's no specific prayer or demand for attorney's fees there. Let me look at the the motions for default judgment.
Yeah, from what I can see, your motion just asks for principal, interest, and finance charges.
I've looked at one motion, that's true in that one. I'm just checking the second motion, Your Honor. I agree.
All right, so I have a proposed judgment here that was submitted along with the motion, which tracks with the testimony and excludes a claim for attorney's fees, and I'm going to go ahead and sign that judgment.
All right, thank you, Your Honor.
All right.
Except that I'm not sure the amount of the attorney's fees in that, excuse me, the amount of the interest in that proposed order is correct. I think it was the amount of interest in that proposed order was calculated through the date it was filed, I suspect.
You're probably right. I have,
That's why I did Plaintiff's Exhibit 4. If the court likes, I can simply submit another one.
yes, please submit an updated order. And I'll sign that.
That goes to Mr. Townsend.
Yes.
All right, I will do that very shortly.
All right, so that takes care of position 15. Your witness may be excused on that one.
Thank you.
Thank you, Your Honor.
I have, do you have another one, Mr. Nickerson?
No, that's my only one, Your Honor.
All right, you may be excused, sir.
Thank you.
All right, next I have position 16, Plateau West Homeowners Association versus Barrett.
Morning, Your Honor. Ben Ost on behalf of the plaintiff. I have one witness and we're ready to proceed.
All right, you can go ahead.
Mr. Combs, please raise your right hand. Do you vow and affirm the testimony you're about to provide to this court is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Combs, please state your full name.
Brian Edward Combs,
And who is your employer, Mr. Combs?
Fieldstone Association Management.
And what's your title?
I'm a community association manager.
And how long have you been a property manager with Fieldstone?
3.5 years.
Are you responsible for overseeing the management and accounting for Plateau West Homeowners Association, Inc., the plaintiff in this case?
Yes, I am.
Do you keep accounting documentation and your responsibility as property manager for the individual owner accounts?
Yes.
Specifically, are you familiar with the account for Miss Cecilia Barrett, the defendant in this case?
Yes, I am.
And does the defendant own property within the Plateau West community?
Yes, she does.
And pursuant to that ownership, is she subject to the declaration of protective covenants, conditions, restrictions, and easements for Plateau West?
Yes.
And does the declaration provide the association with the authority to impose assessments on owners of property within Plateau West community?
Yes, it does.
Has the defendant paid each and every assessment as they've come due for her lot, which is commonly known as 442 Plateau Place Northwest, Atlanta, Georgia, 30309?
No.
And I'll direct your attention to what's been marked as Exhibit B and is attached to the complaint. Do you recognize that document, Mr. Combs?
Yes.
And can you describe it for the court?
It's the Exhibit B, would be a listing of every assessment that was placed in there, and also would be a listing of any type payment made.
Is it the regular practice of the association to create and maintain similar account ledgers in order to facilitate the collection of association assessments?
Yes.
And were the entries on that ledger made at or near the time the charges were incurred by someone with personal knowledge of the charges and a business duty to report those charges?
Yes.
And finally, is the ledger a business record kept in the normal course of business for the association?
Yes.
According to the association's records, how much does the defendant owe the association for non-payment of assessments through 2021?
$5,500.
And does that include accelerated assessments through the 2021 calendar year?
It does.
And does section 4.4 of the declaration authorize the association to accelerate the assessments when monthly assessments are not paid as they come due?
Yes, it does.
Is the association authorized to apply interest at the rate of 10% per annum on unpaid assessments?
Yes.
And how much interest does the defendant owe?
$208.32.
And finally, is the association authorized to apply late fees of 10% on each unpaid assessment?
Yes,
And how much does the defendant owe in late fees?
$55.
And has the association incurred any additional fees in the efforts to collect the past due assessments?
Yes, attorney fees, court costs, things of that nature.
Your Honor, I have no further questions for the witness.
All right. And anything you wish to add on your
Permission
in your
to
place?
testify as to the fees. My name is Benjamin Austin. I'm an attorney duly authorized to practice law in the state of Georgia and a partner with the law firm Duro & Duro. I've been practicing law for 10 years and have been with this firm for 6 years. Duro & Duro has performed legal services on behalf of Plateau West Homeowners Association, Inc. in this matter since 2021 at a rate of $225 to $250 per hour and paralegal rate of $95 per hour. In my experience, these rates are reasonable and customary in the Atlanta area. It's a regular practice in my firm to bill time for the legal services we perform, and the time and a description of the services is entered at or near the time the association incurs the charges by a person with personal knowledge of the charges and a duty to report those charges. The billing statements are generated on a monthly basis, and the association pays those fees on a monthly basis as well. The legal services and court costs in this case include 11.2 hours of attorney and paralegal work and have resulted in expenses to the association in the amount of $1,668.44 and court costs in the amount of $264. The hourly rates were performed, time spent, and the total expenses incurred for legal services in this case are reasonable in light of the nature and complexity of the work involved. And all of those fees have actually been billed to the client with the exception of 2 hours for preparation and attendance at today's hearing. Both the declaration in Georgia law support the recovery of reasonable attorney's fees, and the association respectfully requests an award of attorney's fees in $1,668.44 and court costs in $264. And Your Honor, I do have an updated final order and judgment amending only the attorney's fees from the proposed order submitted with the default. And I'm happy to provide that to the court.
All right, you can send that to Mr. Townsend and we will get it entered.
Thank you, Your Honor.
All right.
May Mr. Combs be excused, Your Honor.
Combs, you're excused. Thank you, sir.
Thank you.
All right, let's go to your next one, which is Waters Cove Homeowners Association versus Stafford.
All right. Ms. D'Ambruoso, and I apologize if I butchered your last name. I don't believe I've actually ever said it before. Barbie, would you please state your full name for the court?
Yes, you did good. Barbara Ann D'Ambruso.
Would you please raise your right hand? Do you solemnly swear and avow that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state, who is your employer?
Homeside Properties.
And are you responsible for overseeing the accounting and collection of assessments for the Waters Cove Homeowner Association, the plaintiff in this case?
I am.
Are you familiar with the accounts for Waters Cove?
Yes.
Specifically the account for Miss Teresa Stafford, formerly known as Miss Teresa M. Bortles, the defendant in this case?
Yes.
Does the account for the defendant show an outstanding balance?
Yes.
And does the defendant own property within the Waters Cove community?
Yes.
And by owning property, is the defendant subject to the terms of the Declaration of Waters Cove? The Declaration of Protective Covenants, Conditions, and Restrictions for Waters Cove?
Yes.
I'll direct your attention to what has been marked as Exhibit B in the plaintiff's complaint. Do you recognize that document?
Yes.
Can you describe it for the court?
Sure. It's an account ledger of her finances.
For the defendant's finances with the association?
Correct.
Is it the regular practice of the association to create and maintain account ledgers in order to facilitate the collection of association assessments?
Yes.
And were the entries on the ledger made at or near the time the charges were incurred by someone with personal knowledge of the charges and a business duty to report those charges?
Yes.
Is the ledger a business record kept in the normal course of business for the association?
Yes.
According to the association's records, how much does the defendant owe the association for non-payment of assessments through 2021?
$1,510.85.
And is the association authorized to charge interest on each assessment that is not paid on or before the due date?
Yes.
And what is the amount of interest on defendant's account?
$59.64.
And has the association incurred any additional fees in their efforts to collect the past due assessments?
Yes, attorney's fees and court costs.
No further questions for the witness, Your Honor.
All right, then you have some testimony for me.
I do. Would you like me to run through the introduction or skip straight to the amount performed in this particular case?
Just the amount in this particular case.
All right.
I'll
Thank
take
you.
official notice of your prior recitation.
Thank you, Your Honor. This firm has been performing services on behalf of Waters Cove since 2020 at an attorney rate $225 to $250 and a paralegal rate of $95 per hour. This has resulted in 10.5 hours of attorney and paralegal work in this matter, which equals attorney's fees in the amount of $1,544.51 and court costs in the amount of $283. Once again, the hourly rate, work performed, time spent, and total expense incurred for legal services rendered in conjunction with this case are reasonable in light of the nature and complexity of the work involved. All the attorney's fees have been actually incurred and billed to my client with the exception of 2 hours for preparation and attendance today. Once again, the declaration and Georgia law support the recovery of reasonable attorney's fees, and the association respectfully requests an award of $1,544.51 in attorney's fees and $283 in court costs. And Your Honor, once again, I'll submit an updated proposed order to Mr. Townsend.
All right, you can submit that order and we will get that signed and entered.
Thank you, Your Honor.
All right, and let's go to your last case, which is Deep Creek on High Point versus Angelia Carter.
No, apologies, Your Honor. May my witness be excused?
Yes, your witness may be excused.
Thank you.
Thank you.
All right, Ms. Carter, you understand where we are, where the posture of this case is?
Not necessarily. I received the paperwork, but I didn't really understand what it was. But I do understand that I am that is referring to my delinquency in my homeowner's payments.
All right, so that's correct. So what has happened is the homeowners association filed a lawsuit against you seeking to recover unpaid assessments. Our records show that you did not respond to that lawsuit in the time you were required, and so the case was placed in default. They made a motion for default judgment based on your failure to answer.
And what exactly does that mean?
That means that unless you have some legal excuse, which I do not see in the record, that they're entitled to judgment against you and that all that's left for them to do is to prove the amount.
I don't have anything legal. I can tell you that now, but I just don't really having a rough time. So
Well, let me ask you this, let me ask you, Mr. Ost, is there some room for discussion as to maybe a way to try and work this out?
Yes, Your Honor, we'd be happy to discuss with the defendant in a breakout room if she's willing.
All right, so Ms. Carter, I'm going to put you in a breakout room with Mr. Ost and you can have a discussion.
Okay.
And see if you can work it out.
Okay.
Your Honor, could you please also include my witness? I think her name on the Zoom call is Vicky.
All right. So now let's come back. To you, Mr. Davis. We lost you for,
Sorry about that.
we lost you for a little bit, but hopefully we got you back and we're ready to go ahead with Mr. Torres.
Everyone see my screen or?
We just see like, yeah, the bullets. If you click on it, we should be able to see the exhibit.
Can you see it? Yes.
Not yet.
Okay.
Yeah, it's still not showing.
Okay. What about now?
Yeah, we can see it.
Okay, perfect. Mr. Torres, are you familiar with this document?
Yes, sir.
Okay. What is the document? Who was this? What was the document? Who was the document prepared for?
This is a workers' compensation policy for Atlantic Construction LLC.
Okay. And on the second page, can you identify this document?
This is the declarations page.
Okay. And who is the insured?
The insured is Atlantic Construction LLC.
Okay. Mr. Torres, I am going to go to page 11. Give me one moment. And if you can read the first sentence of provision G.
You will let us examine and audit all of your records that relate to this policy. These records, oh, that's it. The first sentence.
Go ahead. Yeah. You're fine. And after the audit, did Travelers did conduct an audit in this case, correct?
That is correct, yes. An audit was conducted.
And a notice was then sent to the defendant. Is that correct?
Yes, sir.
Okay. Have you had an opportunity to review the notice that was sent?
Yes, sir.
Okay. Your Honor, at this time, I'll submit the premium adjustment notice as plaintiff's exhibit C. Give me one moment. Mr. Torres, based on this notice, what were the audit results?
The premium audit results resulted in a premium of $35,252.
Okay. In addition to this notice being sent to the defendant, were there any other notices sent to the defendant?
When the premium adjustment notice goes out, there's this page, and then there's another section called the exposure comparison that also goes to the insured.
Okay. And have you had an opportunity to review that page, the exposure comparison page?
Yes, sir.
Okay. Your Honor, at this time, I'll submit the exposure comparison as plaintiff's exhibit C. Mr. Torres, based on the exposure comparison, what caused the audit amount to be so different than the initial estimated premium?
So the original policy had an estimated payroll exposure of $12,000 for a class code 5437 carpentry installation of cabinet work or interior trim. At time of audit, the exposure for that classification was actually $23,453, so almost double the amount. In addition to that, the insured had several contract laborers that he utilized in different fields. So several additional class codes were added to the policy, resulting in additional premium.
And based on your experience after this, how does Travelers determine the final balance that is then sent to the defendant?
But you take the exposure and then you multiply by the rate, which is established by the state of Georgia. And then that determines the actual premium. And then you deduct any payments the insured already made for the policy initially. And then the balance is what the outstanding balance is.
And when the final balance is determined, what is then sent to the defendant?
But we'll have a bill, and in this case, we have the statement of account.
Okay. Your Honor, I'll just submit to the court the statement of accounts for Atlantic Construction LLC as Exhibit D. Based on the audit, what was the earned premium amount, Mr. Torres?
$35,252.
And how much was the defendant credited for?
$3,104.
And that's the monies that he has already paid towards the insurance. Is that correct?
Yes, that's the money, the payment he made initially to take out the policy.
Okay. And how much is the unpaid balance?
$32,148.
And to date, has the defendant disputed the audited results?
No, sir.
Your Honor, I have no further questions. I would just ask the court to award damages in the amount of the past due amount of $32,148 plus court costs.
All right. I will grant judgment in that amount. If you would submit a proposed final order in judgment in that amount, we will get it signed.
Thank you, Your Honor. May myself and my witness be excused, Your Honor.
Yes, you may be excused.
Thank you, Your Honor.
Mhm.
All right. Let's come back to Louis Brisbois versus Uniji.
Yes, sir, Your Honor, you need you on the line.
All right, so we have been trying since we started, and we have not been successful in finding a court reporter for today. If either of you want it taken down, do either of you
No.
want to now?
No, Your Honor.
No, Your Honor.
All right, so we can go forward. So the purpose of today's hearing is to talk about damages.
Yes.
All right, so I'm prepared to hear from Louis Brisbois' witness, and Ms. Uniji, you will have an opportunity to ask any questions you have of the witness. Before we get to that, I see Mr. Host is back. We have a report.
Yes, Your Honor. We have agreed to terms of a settlement. And so with the court's permission, I'd like to draft up a consent order that will be, both parties will be signing and submitting to the court.
All right. Ms. Carter, just want to confirm with you, you have a consent agreement with Mr. Ost?
Yes, Your Honor.
All right. All right, so we will let you have time to paper that up and submit that consent order, and then we'll get it entered.
Okay.
All right, thank you,
Your
Ms.
Honor.
Carter. Thank you,
Thank
Mr.
you.
Ost. All right, Ms. Bellamy and witness, I appreciate y'all patience. Y'all can go ahead.
Thank you, Your Honor. So today, we're actually seeking, my client is seeking $35,954.14. This is the amount that was stated in our request, in our renewed motion for default judgment. Essentially, that amount breaks down to $11,004.50 in the principal amount. And we attach the invoices as Exhibit 1 to our renewed motion for default judgment. And those invoices reflect the work which was performed for the benefit and accepted by Ms. Joy, and were kept as business records of those invoices which were previously sent to Ms. Joy. As stated at the last hearing, this partner, LaRon Rogers, he handled her divorce in 2012. And this account has remained uncollectible since then. We're therefore seeking prejudgment interest at a rate of 18%, and that totals $22,112.99. We are also seeking attorney's fees in the amount of $2,834.65. Together, that totals $35,954.14, Your Honor.
All right, Ms. Unije, any questions for Ms. Bellamy regarding the amount?
Your Honor, can you please indulge me to explain myself? I'm not an attorney and I don't have money to afford one. Can you please indulge me to hear me out, please?
Yes, I will.
Thank you, sir, Your Honor. Your Honor, I owe Attorney Roger. I don't owe him anything. When I met him at his office, Attorney Roger promised that he will get my ex-husband, which is a cardiac surgeon here in Atlanta, to pay for my alimony for up to the duration, either I remarry or finish my nursing school. Attorney Roger failed to do so. I'm having anxiety, I'm sorry, Your Honor. I asked Attorney Rogers if he can request the court to order Dr. Wheeler to pay all his hourly legal fees. He said yes. I also told Attorney Rogers to request for alimony for my ex to pay for my nursing tuition, dependable car, and other things like furniture to be able to start new life. He said yes. Attorney Roger knew quite well that I reminded him so many times during the proceedings to request for his hourly services, and he failed to do so. I made it abundantly clear to Attorney Roger that I have no money or any source of income for any legal fee. His representation, Attorney Roger's representation, was below legal standard. He did not get me alimony. The alimony he got me, I'm married. Remind you, Your Honor, I'm married to a cardiac surgeon and I work in his office. Attorney Roger was only able to get me $1,500 for 6 months. No dependable car that I requested. Not even getting nursing school tuition for me. I got nothing from my divorce. He promised me that he will get all my requests because Attorney Roger said to me in his office, it's a standard request, it's no brainer. I wondered if I have represented myself, if I could have a different outcome. I deeply regretted the day I walked into his office. Till this very day, I am homeless. I depend on the state food stamp to eat. It has not been easy for me and my children. I am not making enough to sustain my basic need. Attorney Roger had no human decency. He took me to court to collect his fee, all this time knowing full well my plight. He failed to get his fees from Dr. Wheeler, who has the money to pay him. Remember, Dr. Wheeler is a cardiac surgeon who initiated the divorce. I made it crystal clear the need to get his money from my ex-husband. Attorney Roger left me no choice but to grieve him for his lack of adequate representation that left me and my children in the state of destitution. I have suffered immensely with my children, and he continued to add to my suffering by looking to garnish the little money I make working in daycare. I pray that you will look into this matter. Attorney Roger should have no business practicing law since he cannot himself deal justly to his client that trusted him. He betrayed my trust. He failed to pursue all my legal requests that I have already pointed out that he promised, but failed to do so. Your Honor, I have reported Attorney Roger. I have grieved him. I have reported him to the grievance committee. And Your Honor, I have a copy of the grievance. And please, Your Honor, how can I send it to you now? And I want it to be part of this case or court file.
Your Honor, I would object to that solely because we're not here today based on the merit of the representation that was provided in 2012. And personally, I cannot attest to that as I was in high school during that time. What we're here today for, and that's also why I'm heavily relying on this renewed motion for default judgment, is that the undisputed fact shows that Ms. Joy retained Mr. Rogers to handle her divorce. He provided those legal services. She was divorced from her husband in 2012. We've attached the invoices. This account has remained uncollectible since 2012. It's now 2021, almost 10 years. My client, Louis Brisbois, is entitled to the amount that we're seeking. So I would, I sympathize with Ms. Joy and I'm not personally familiar with that, but the grievance that has no bearing on what is actually owed to our client. Her answer was untimely. It's, my client is entitled to the amount that we're seeking. She retained Mr. Rogers to handle her divorce, and he did that in 2012.
Your Honor, can I say something?
And the amount that was charged for someone of his status, a partner, one of the most prominent and experienced African-American attorneys in the Southeast region, only charged $300 an hour, which is very reasonable. He was the only attorney who billed on a file as reflected in Exhibit 1 that was attached to our renewed motion for default judgment. So we would submit to the court that all costs have been reasonable and customary.
Your Honor, can I say something?
Go ahead.
Okay, you just said earlier that you were in high school. You were not present when I was in Attorney Rogers' office and the door closed what he promised me. Why is it that Attorney Rogers is not here today to argue what he promised me? I'm homeless with my case. Attorney Rogers sent stuff to where I'm no longer in. You guys are well known. Like you said, very prominent attorneys. Like when Attorney Rogers was represented me, I told him to ask for all his legal fees. My ex is a renowned cardiac surgeon. I work for his practice. That's my only source of income. He knew that. He failed to do so. Everything, I left that divorce with nothing, squatting in people's house. I was kicked out of my apartment after 6 months because Attorney Rogers, his representation was below standards. I'm jobless. I have proof with Labor Department. I have proof with food stamp. I even went and applied. I have proof with Community Affairs to help me, including Fulton County homeless people. My caseworker is Kenneth Morgan. I have proof I'm homeless. I depend on government health care with my children. We depend on government food stamp. So if I'm making enough, why did I qualify for all that? I have to show proof of my income. I can't even make enough to even sustain my basic needs. Right now, I'm outside while you're in the office. I'm outside on this call. I have doctor appointment due to all this stress. I almost have nervous breakdown because of this call coming. Who Attorney Rogers, just heartless attorney, going after a client that he knew where he could have gotten his money And I keep saying, Attorney Roger, make sure you get your money. How can I marry a cardiac surgeon, live in a big house in the country club, then become homeless with my kids because of his representation? And he have no remorse. I left that marriage, not even a car to drive my children. How will you feel as a woman? How will you feel? I'm here, stranded.
Okay, Ms. Unije, I hear you. I've heard you. I sympathize with the issues that you're dealing with. And I can't make any comment on the morality of the quality of the representation or lack thereof, the morality of suing or the morality of trying to collect on a judgment. All I can do is decide the case based on the facts and the law before me. And as we've talked about before, we can't get to the merits of the case, which you are discussing. We can't get to the merits of the case because we don't have a validly filed answer, and you're in default. They're entitled to judgment. There's been no dispute as to the amounts that have been purportedly incurred on your behalf. So, you know, at this time, I'm going to have to grant their motion for default judgment and award them a judgment in the amount of the fee that they seek. I don't know that it's collectible. I don't know that it will ever be collected, but they are entitled to a judgment for the unpaid fees. You know,
from a woman that don't have a job, that is struggling with this bad economy. I've already reported him to the grievance committee, and I want a copy to be in this case file because I'm gonna sue Attorney Roger for poor representation because this is putting more hardship on my end and my children. We are homeless, man. Why can't people feel people's pain, man? I'm going through a lot, and this lawyer, I did my research. Some attorneys that are not even as big as their law firm have already, right up for their client. And this law firm that is very big keep pursuing a poor lady and her children. May the God in heaven judge. May he judge.
Ms. Unije, if there's anything else that you wish to file in your case, you can come down to the courthouse.
I will. I want this paperwork.
There are other potential legal avenues you have with regard to the judgment. I can't advise you as to what those are. There'll be a final judgment, and you have the right to appeal within 30 days of the final judgment. I can't advise you further on as to the specifics you, but there is help for you in the courthouse if you wish to take advantage of it.
Your Honor,
yes, sir. And I'm appealing the amount. I don't owe Attorney Roger anything, and I'll be appealing and I'll be suing for his legal representation. Because of Attorney Roger, I'm depending on the state. I'm a liability to my children on the state because of him. If he have represented me well, I could have gotten my nursing degree, be able to take care of me, and be able to work in the system and take care of the sick ones. But Attorney Roger could not do that for me.
All right, Ms. Unije, we're going to, we've heard you. I've told you everything that I have to do at this time. So we're going to move forward and enter the judgment and go from there. Ms. Bellamy, if you would submit a proposed final judgment.
Yes, Your Honor.
And we will get it entered.
Thank you, Your Honor.
All right.
May we be excused?
Ms. Bellamy, you may be excused.
Thank you, Your Honor.
May I be excused, Your Honor?
You may be excused.
Thank you, sir.
All right. I think that takes care All of our cases. Done.